Hello everyone, welcome to Drishti IAS. You're watching the NCERT Foundation Series wherein we study the subject of political science with the help of MCQs and PYQs wherever relevant. So without further ado, let's plunge right in. We had covered some topics of chapter 2 of your class 11 NCERTs and we had seen how many questions were lifted directly from this chapter. So, we had covered the importance of rights, a couple of questions on fundamental rights, Bill of Rights, as well as a question or two on directive principles of state policy, and we are going to carry forward from where we left in the previous video. But I'm sure you must have by now understood how important NCERTs are and how merely reading them brings you so much of clarity as well as some assurance of being able to attempt your prelims questions. Alright, so let's begin with the previous day question. Consider the following statements. 1. Fundamental rights impose positive obligations on the state. And 2. Directive principles impose negative obligations on the state. Which of the statements given above are correct? Now it says fundamental rights impose positive obligations on the state. Let's examine this statement. When we talk about fundamental rights, we actually bring them in discussions of a constitutional government. And any constitutional government by nature is essentially a limited government. Limited because it is limited by the framework of the constitution. And these fundamental rights actually determine the limits to what a government can do or what it cannot impose on its citizens. That is of course the work of the constitution, but within the constitution, fundamental rights hold the utmost importance when talking about limitations, constitutional limitations on the powers of the government, powers and functions of the government. Now when we talk about fundamental rights, think about various rights. For example, freedom from discrimination. The state shall not discriminate simply on the basis of religion, race, caste, sex, and place of birth. Or there is protection in respect of conviction for offences, right? Or when we have the right to life and personal liberty, we are actually saying that the state shall not deprive a person or a citizen of his life save by the authority of law. So we are here seeing that these are basically negative obligations that are being imposed on the state. They are not affirmative obligations. They are not positive actions that the state is expected to do in order to enhance the welfare of its citizens, but rather negative limitations or let's say certain constraints that have been put on the state. The second part is about directive principles. Now we said in the preceding video that directive principles basically talk about the idea of, or the ideal rather, of a welfare state. This ideal is reflected in part 4 of our constitution, which is DPSPs. Now, what is the ideal of a welfare state? The welfare state basically means that the state is taking active actions or actively participating in increasing the welfare of its citizens. That means the state is going beyond law and order. It is not simply a night watchman state, but rather it is taking affirmative actions in the form of trying to establish political, social, and economic justice for its citizen. If we consider a few DPSPs, we know that it's talking about equal wages for equal work or enhancing the conditions of workers, all right, or promoting certain cottage industries, all right. So these are what? These are active decisions, active participation that are meant to increase the or improve the governing of its citizens. So hence these are not negative but rather positive obligations on the state. Of course, they are non-justiciable, but that doesn't take away from the fact that they deal with a lot of affirmative action over here. Positive action is being talked about. Hence, these two need to be interchanged in the sense that fundamental rights are negative obligations on the state, whereas directive principles impose positive or affirmative obligations on the state, and hence neither of the given statement is correct. Therefore, option D happens to be our correct answer. I hope that made sense to you. Now let's look at this question. What is the position of right to property in India? And this happens to be a PYQ. Now, what about the right to property? So let's remember that right to property was actually a fundamental right up until 1978. It was a fundamental right under Article 19(1)(f) and then Article 31. Article 19(1)(f) said that any citizen of India, notice the word citizen of India, had the right to acquire, hold and dispose of property. This right was granted only to citizens of India. All right. And Article 31 talked about deprivation of property without or protection from the property being taken away without adequate compensation. So this had to do with adequate compensation. Now, in 1978, via the 44th Constitutional Amendment Act, the Articles 19(1)(f) as well as Article 31 were deleted. And in their stead, Article 300A was inserted. With this, the article read that no person shall be deprived of their property without the authority of law. Without the authority of law. Notice here the use of no person. So while as a fundamental right to property was guaranteed only to citizens, when it became a legal right or a constitutional right, it was guaranteed to any person and not limited to the citizen itself. All right. So with the help of this background, let's try to attempt our question. So position of right to property in India. A, legal right available to citizens only. No, we have just ruled this out. It is available to everybody. B, legal right available to any person. Yes, that is in fact accurate. C says fundamental right available to citizens only. That was before 1978. But current position in India is actually resonating with option B. D says neither a fundamental right nor a legal right. This is inaccurate, and we have option B as our correct answer. Moving on to the next question. Cultural and educational rights ensure that. Now here we are talking about cultural and educational rights, and these are covered in Articles 29 and 30 of our Constitution. What does Article 29 say? Article 29 talks about protection of interests of minorities. So it is basically pertaining to protection of minority interests. Now, when we talk about minorities, the Constitution actually says that any segment, notice I use any segment of people that have a distinct language, script, or culture. Language, script, and culture. So any section of the people, any section of the population that have a distinct script, language or culture are entitled to preserve their language, script and culture. Also, the same article prohibits any discrimination on the grounds of religion, race, caste and language. So it prohibits discrimination on linguistic grounds. The very same article. This is what we know about Article 29. What does Article 30 do? Article 30 talks about the right of minorities to first establish and then administer religious institutions. We are talking about the right of minorities, educational institutions. Now here again, any minority that is based either on religion or on language. So the Constitution hasn't specified the grounds here, whether it has to be only religion or language, but rather they have taken an inclusive approach and said any minority, whether religious or linguistic, can not only establish but also administer educational institutes. All right. So based on this information, let's try to attempt this question. Option A says only religious minorities can establish schools. We just read a moment ago that not just religious but also linguistic minorities can establish educational institutions. So we can safely rule this option out. Option B says all minorities can preserve their language and culture. Absolutely. Any segment of the population that has a distinct language and culture can preserve it. Option C says the state must provide free education to minorities. Now, when we were reading about Article 29, we said that the state cannot discriminate. But it never said that the state is constitutionally bound to provide free education, all right? So this again gets eliminated. Option D here says religious teaching is compulsory in minority institutions. Remember, we have talked about the fact that wherever you see very emphatic words like all, only, absolutely, here again compulsory, it is likely a red flag. However, even here, although it is of course a red flag, we need to remember that religious teaching is optional and the people are free to, minorities are free to choose their content. So here again, we arrive at the correct answer, which happens to be option B. With reference to the provisions contained in Part 4 of the Constitution of India, which of the following statements are correct? Again, a previous year's question and a very basic question, a straightforward one. Now we are talking about Part 4. Part 4 simply means Directive Principles of State Policy. Now, if we have talked about Directive Principles of State Policy, we know that these are basically fulfilling the ideal of a welfare state, which means they intend to provide and promote political, social, as well as economic justice. Political, social, as well as economic justice. That is the whole idea. And it does so in various forms. So, for example, it strives for promoting equal work for equal wages for equal work, all right, or better working conditions for persons in factories and so on. However, they are non-justiciable, which means they cannot be enforced by any court of law. That is the caveat. Yes, the government must strive to include these principles in their governance, but nobody can move any court saying that this has not been implemented, all right. Now, the first option, first statement says they shall be enforceable by courts. This is incorrect. And the second says they shall not be enforceable by any court. This is correct. Whenever you see two statements that are contradictory in nature, one says yes, the other says no, one says will do, the other say will not do, all right. Whenever they have the relation of contradiction, you should be aware that only one is going to be correct, all right. So this way your life will become easier in the examination. Of course, both of these contradictory statements cannot be correct. Now, when we talk about option 3, the principles laid down in this part are to influence the making of laws by the state. Absolutely correct. They are fundamental to the governance of citizens. So we have second and third option, or second and third statement correct, and therefore option D is our correct answer. Which of the following best describes the functions of NHRC? Now, what is NHRC? We're talking about fundamental rights, which also includes, or which also takes from human rights. Now, NHRC is basically your National Human Rights Commission. National Human Rights Commission. Now, this was established in 1993 by an act of the Parliament, which is known as the Protection of Human Rights Act, the PHRA 1993, which makes this commission a statutory body. It is not a constitutional body, but rather a statutory body, because it was formed or established on the basis of a statute or law, which is the Protection of the Human Rights Act of 1993. Now, what is the composition of this commission? What is it composed of? How many members does it have? So, this composition has a chairperson. The chairperson is who? The chairperson is a former Chief Justice of India. All right. One member has to be a retired or a sitting judge, a former or a sitting judge of the Supreme Court, and another member should be a former Chief Justice of a High Court. And this actually displays how important the functioning of this commission is. All right. Then it also talks about 3 other members, out of which one should be a woman. At least one should be a woman who have knowledge or practical experience in the field of human rights. So every attention, every care has been taken to ensure that it deals with people who are well versed in justice, in the science of justice, in the art of justice, in judiciary. All right. Other than this, these are full-time members. But other than this, of course, there are certain officio members, deemed members. These are not full-time members, they are deemed members. And who are they? They are the chairpersons of the following commissions. 1. National Commission for Scheduled Castes. 2. National Commission for Scheduled Tribes. 3. National Commissions for Minorities. 4. National Commission for Women, NCW. 5. National Commission for Protection of Child Rights. 6. National Commission for Backward Classes. And finally, National Commission for the Persons with Disabilities. So the chairpersons of these 7 commissions are the ex officio members of NHRC. Now, what is the job of NHRC? NHRC. What is the job? What is the functioning? To inquire into excesses or to inquire into violations of human rights, as the name suggests. For example, custodial deaths, custodial torture. Sometimes people disappear from custody itself, all right, from jails. They're unaccounted for. Of course, conditions of jail. So many other things, all right. So these are some of the examples of their function. And of course, they can take suo motu inquiry. They can inquire by themselves. Of course, somebody can file a petition, but they can also do so on their own. That is, they may take suo motu charge. However, the only caveat is that their recommendations are non-binding on the government. They can only recommend. Their function is only advisory and not binding. So, with this background, let's attempt the question. 1. Inquire into complaints of violation of human rights. As the name suggests, it's fairly obvious. 2 says recommend prosecution or disciplinary action. Absolutely, it can recommend. 3. Enforce judgments against public officials. Now, that is unfortunately not true. That is not correct, and it cannot enforce judgments. It can only recommend. And 4th, visit jails and detention centers to study conditions of inmates. Absolutely correct. All right. So we know that statements 1, 2 and 4 are correct. We can eliminate anything with 3, and the correct answer is option B. Now the next question is, which of the following pairs are correctly matched? And we have certain writs and their purpose. Now, there are altogether 5 writs. Writs are what? Writs are basically legal orders, or let's say they are written orders. What for? They are basically for the purpose of judicial review. They are an incredible judicial review mechanism. They are issued either by the Supreme Court under Article 32 or by the High Courts under Article 226. Now, basically, they are issued under the right to constitutional remedies under Article 32. And the Article 32 is known as the heart and soul of the Indian Constitution. All right. Now, when we talk about the Supreme Court can issue writs to enforce fundamental rights, to rectify situations where fundamental rights have been violated. Whereas when we talk about High Court, then under Article 226, its jurisdiction is wider. So it may issue writs not only in case of the violation of fundamental rights, but also in other matters. All right. Now we have 5 types of writs. They are habeas corpus, mandamus, quo warranto, and certiorari, along with prohibition, which is not mentioned in your question. Let's look at them one by one. So here when we talk about habeas corpus, it is literally translated as you may have the body. Habeas corpus is literally translated as you may have the body. Now when somebody has been arrested without being given proper grounds, or is not being produced before the magistrate, basically when someone is unlawfully detained, then the Supreme Court under Article 32 may issue the writ of habeas corpus. Alright, if someone files a petition that my known is unlawfully detained. So for example, somebody was going to a peaceful protest, somebody participated in a peaceful protest, but they were arrested without being given grounds for their arrest. No reason was provided. They were arrested and they were not even produced before the magistrate within 24 hours. Then their known may actually file a petition in the courts, and in response to correct the wrong, the Supreme Court or High Court may actually issue the writ of habeas corpus, alright, which is against the unlawful detention of a person. The next writ is mandamus. Mandamus literally is translated to we command. It is basically a command. A command given by whom? A command given by a higher court. A higher court. To whom? To, of course, either a lower court or a tribunal or a public body or an official to fulfill their duty. If a legal official person is unable to fulfill their duty or is shirking, avoiding their duty, then this writ may be issued. All right. For example, a person has filled a form. I am a person and I have filled a form to get my birth certificate from the municipal corporation, and I've gone through a tedious process and I've filled multiple forms. I've done so thoroughly and I've followed due diligence, and yet I'm unable to receive my birth certificate. Then I may file a petition in the courts and they may actually issue the writ of mandamus, which is they command the municipal corporation to issue a birth certificate to me, to the concerned person. The next one over here is prohibition, which literally means to forbid. Now again, who is going to forbid? Of course, the higher court. Whom are they going to forbid? Of course, the lower courts or the tribunals. Why are they going to, and what are they going to forbid them from? From encroaching upon another person's jurisdiction, another organization's jurisdiction, basically for going beyond their own jurisdiction. All right. So of course, if a court, a lower court or a tribunal is proceeding with a case on which it has no authority or no jurisdiction, which does not fall under its jurisdiction, then a higher court is going to prohibit the lower court from pursuing that case. All right. Then there is certiorari. Certiorari is basically to be informed. Certiorari means to be informed. Again, issued by a higher court, wherein it transfers the cases from a lower court if they feel that a review is needed, and if they feel that there has been a violation of either certain legal principles, constitutional principles, or principles of natural justice, then the higher court can actually quash the case, quash the judgment, quash the order of the lower court. All right. So again, if an order has been unfairly passed, then the courts can quash the order. Finally, quo warranto, which translates to by what authority. This is basically an inquiry into someone's claims to a public office. So for example, if a person has been appointed as the chancellor or a vice chancellor to a university, and if we feel that they do not meet the eligibility criteria and the qualification, then we can file a petition, and the court, if it finds that there is indeed a mismatch, it will issue the writ of quo warranto. By what authority do you stake a claim to this office? All right. So these are the 5 types of writs, and on the basis of this information, let's try and attempt the question. A, habeas corpus, like I said, to have the body of. It says to secure the release of a person unlawfully detained. Absolutely correct. Option B is mandamus, we command. It is to compel a public authority to perform its legal duty. Absolutely. C, quo warranto, by what authority? To inquire into the legality of a person's claim to a public office. Absolutely correct. And D, certiorari, to transfer a case from a lower court to a higher court for review. Absolutely correct. And if the higher court observes that the case or the ruling that has been passed has been done unfairly or violates the principles of justice, then the higher court can also quash that ruling. So all of these are correctly matched, and hence option D is the correct answer. Question 6 says, which of the following statements about fundamental duties are correct? Now, fundamental duties were added by the 42nd Constitutional Amendment of 1976. And what are fundamental duties? Of course, duties that citizens have to abide by. Are they enforceable? Of course, they are not. In total, there are 11 fundamental duties as of now. Originally, there were 10, but the 11th duty was added by the 86th Constitutional Amendment of 2002, which talked about the duty of every citizen to provide opportunities for education for its ward for until the age of 6 to 14 years. All right. So, but they are again not justiciable. We need to understand they are not justiciable, which means they cannot be enforced by any court. However, various laws can be made in order to enforce these duties. So various environmental laws, for example, have been made so that these duties can be abided by. All right. So let's consider first statement. It says they were incorporated in the Constitution by the 42nd Amendment Act of 1976. Indeed, they were. Second, they apply to both citizens and foreigners residing in India. Actually, no. If we look at Article 51A, which is the article that has been inserted for fundamental duties, it opens with every citizen of India, or it is the duty of every citizen of India. It doesn't really mention foreigners residing in India. So we can rule this out. Statement 3 says they are enforceable by law under Article 51A. So no. Now this statement may appear confusing. They are indeed enforceable by laws made by the Parliament. All right. But not under Article 51A. So they are not justiciable under this very article, but the Parliament has indeed made various laws in order to enforce some of these duties. All right. So we can again eliminate this and arrive at the correct answer, which is option A, one only. So before I show to you your practice question, I'd like to bring to you the NCERT online course for your UPSC Foundation. And we have, at least in this recent couple of videos, seen how important NCERTs are for you. So of course, this course brings for you 150 plus classes as well as 2 years validity. Now, good thing over here is that if you purchase our NCERT online course and visit any of our offline centers, then you will get a full fee waiver equivalent to the amount that you've paid for the NCERT online course. Now, if you want more details, kindly click the link in the description box, or you can call 87501 for more details. And finally, I have for you a practice question. So please take a look at this. And with today's video, we have summed up this second chapter of the Class 11 NCERT. This session again, I hope was very fruitful for you. If you liked today's session or found it useful, kindly like, share and subscribe. Do send us your answers in the comment section. Thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.